Assalamualaikum and a very good morning. I bid to our honorable lecturer. My name is Muhammad Aizul Azli bin Benson, alongside with my team members Nurul Ain Shafia binti Rozman, Muhammad Alif Syami bin Ridwan and Shanta Milia Sayon. Today, we will be presenting our written assignment for land law, which consists of two issues following the questions.
Sufyan is the registered proprietor of agricultural land held under title Geran Mukim, measuring approximately 10 hectares. The land was planted with rubber trees, and Sufyan has now built a row of shop houses on the said land. He rented out 4 shops and used the others as a glove factory. Malik, on the other hand, is the holder of a temporary occupation license (COL) for the land adjacent to Sufyan's land. He had occupied the land for the past 10 years and never renewed his license. Malik recently submitted his application to the state authority for the alienation of the land. The land is situated on a small hill above Sufyan's land. Malik has planted some durian trees and reared fish in a pond. He plans to expand his fish pond and has started to dig more ponds. However, he had caused some movement of the earth as water from the fish ponds flowed down onto Sufyan's land. It has flooded the shop houses and caused damage to Sufyan's factory. Meanwhile, Sufyan has applied to the state authority for alienation of the land occupied by Malik, and fortunately, it has been approved. He was issued a Form 5A for further action. Sufyan, however, immediately entered into an agreement to sell the land to his cousin Amir for 400,000 ringgit. Upon signing the sale and purchase agreement, Amir paid him 400,000 ringgit. The balance will be paid upon registration of the title into Amir's name. However, a few legal issues have arisen. Advise parties.
Question A. Sufyan wishes to sue Malik for the damage caused by the flooding on his land. Malik claims that the flood is an act of God. Advise Sufyan.
Firstly, we will discuss temporary occupational license or TOL and the rights and obligations associated with it. So the TOL serves as a license granted by the state authority, allowing individuals or organizations to occupy state land, mining land, and reserve land for a specific period. One of the key rights and obligation of TOL holder is the option to apply for a renewal. According to Section 67, Subsection 3 of the National Land Code NLC 1965, the TOL does not have automatic renewal. However, the holder may request a renewal from the land administrator, and if approved, the license can be extended for a maximum of 1 calendar year, and it is crucial to note that not more than 3 renewals can be made without the prior written approval of the state authority. The right to the support of land in its natural state is another important consideration. Section 44, Subsection 1, Subsection B of the NLC 1965 stipulates that a landowner has the right to have their land physically supported by adjoining land and underground structure, and this support should not be removed. These rights serve as a protective measure to prevent interference with the property of landowners. The right of support is a negative right, meaning that others should not interfere with the natural support provided by adjoining land. The owner of the adjacent land has a duty to support and refrain from any activity that might endanger the property of others. However, certain conditions must be fulfilled for a person to have the right of support. Firstly, the lower level land must support the land above it. Secondly, the land must be adjoining but with separate ownership. Thirdly, the land must be in its natural state without burdensome structure or weakened by excavation. Lastly, no additional support should be expected beyond what is already present on the land. There are 2 types of support that one may claim for adjoining land or buildings. The first is the cross right of support, which applies when lands are situated next to each other at the same level. So the second is the support of adjacent slope land, which pertains to lands adjoining in a slope condition with one land situated above another. So let's briefly examine a relevant case, Guansun Tin Minings and Ampang Estate Limited. In this instance, the respondents claim that the appellants had withdrawn support from their land due to mining activities causing damage. The court ruled that when subsidence occurs on a neighbor's land, the party responsible for the subsidence is liable for damages. However, if there is a lapse of time between excavation and subsidence and a change of ownership occurs, the new occupier may not be held liable. Additionally, if the subsidence is caused by additional weight from a building or structure, it cannot be considered a withdrawal of support from adjacent land. In a specific case, the applicant will not held liable as the land had been excavated before the occupation. Section 40 of the NLC states that the state land is solely vested in the state authority. Section 41 provides the state authority with the power to dispose state land, reserve land, and mining land. The ways in which land can be disposed of by the state authority are listed in Section 42, subsection 1 of the NLC. These include alienation for 99 years or perpetuity, reservation of state land, granting of lease or reserve land which exceeding 3 years, and issuance of license to occupy state land, mining land, and reserve land under temporary occupational license (TOL). So the land proprietor, licensee, or lessee is entitled to use the land as provided in the NLC, having ownership from the A space to the ground below. However, the right to enjoy the land is not absolute and is subject to paramount and subsidiary rights. Finally, let's explore the case of Madam Cha Siam and Chok Choi Kong Kong Si. In this instance, the plaintiff operated a fish pond under a license while the defendant conducted mining operation on adjoining land nearing the boundary of the fish pond. As a result, the bank of the pond collapsed and leading to water pouring into the mine, and the plaintiff sought the compensation for the loss of revenue and the loss of natural support due to the mining activities. So the court denied the plaintiff claim, reasoning that land that has been excavated is no longer in its natural state and therefore loses the right to support. Furthermore, the presence of water in the pond increased the pressure on the land, further weakening its structure. For question A, the issue is whether Sufyan can sue Malik for the damage caused by water from the Malik's fish ponds flowing down onto Sufyan's land.
Paramount rights or the right of support under Section 44 were not available to the TOL holder. For land that has been alienated, there is a paramount right support right. Malik is not a proprietor due to alienation, hence he is not entitled to the supreme rights provided by Section 44. Malik violated Section 67 subsection 3 by failing to request a renewal since the license will not have done so automatically. Therefore, he was occupying the property illegally since he failed to renew his lease, which he was required to do every calendar year. He had no right to have occupied the property for the prior 10 years. Sufyan's application for alienation was approved, thus he may only assert equal rights to the land. So long as he complied with all the requirements, he is permitted to use his right to support for his property. Sufyan has the right to have his property physically supported in its natural condition by the land close to Malik's land, which is located on a tiny hill below Malik's land, as well as the right to have that support maintained. This is critical to preventing Malik from interfering with Sufyan's land rights, and the aforementioned agricultural property is owned by Sufyan. Sufyan lost natural support from Malik's land and his right not to be harmed by Malik. Malik failed to support him and he did something on his land that jeopardized Sufyan's property. Namely, Malik expanded his fish pond and began digging other ponds. This produced ground movement and water from the fish pond poured into Sufyan's land. It flooded the storehouses and destroyed Sufyan's factory. Sufyan's land is likely to get support from Malik's land subject to certain conditions. For starters, Sufyan's property at the lower level supports Malik's land above it because Malik had no problem with his land. Second, ownership was separate since Sufyan's land was next to Malik and Sufyan is the registered owner of agricultural land, while Malik is the owner of a temporary occupational license. However, the third requirement, Sufyan's land was not in a natural state since Sufyan has built a row of shop houses on the land and Sufyan is the registered proprietor of agricultural land. The land was planted with a rubber tree, but he used the land to build shop houses and rented out 4 shops and used the others as a glue factory, shows that the land was not in a natural state already. Fourth, Sufyan's land wasn't in a weaker position since he didn't need more help. He didn't ask Malik for it because his land was already operating normally before Malik built his fish pond. Sufyan is not entitled to the right of support because his land did not meet all requirements due to the fact that Sufyan and Malik properties are adjacent. In a situation where Malik's land is higher than Sufyan's land are not enough for Sufyan to have the right to make a claim from neighboring property in a second type of support, which is for adjacent slot land. Just like in the case of Madam Cha Sian and Chok Choi Kong Si, the court will deny Sufyan's demand because Sufyan's land held building on it makes it no longer in natural state, and therefore Sufyan has lost the right to support all the land. In conclusion, Sufyan cannot sue Malik for the damage caused by water from Malik's fish pond flowing down into Sufyan land, since Sufyan failed to meet all the requirements in order to claim right for support.
In conclusion, Sufyan cannot sue Malik for the damage caused by water from Malik fish ponds flowing down into Sufyan land, since Sufyan failed to meet all the requirements in order to claim the right for support.
Question B. Amir discovered that the title was not registered in Sufyan's name. He decided to terminate the sale and purchase agreement and requested Sufyan to refund his money. Sufyan claimed that Amir has no valid reason to terminate the agreement. Advise Amir.
Alienation is one of the ways where estate land can be disposed by virtue of Section 40 of the NLC. Alienation grants the proprietor the paramount rights that come with certain restrictions in which they can enjoy as the legal owner of the land. Under Section 76 of the National Land Code, alienation is a term ownership of a land that lasts for less than 99 years or for forever if it is for the sake of public utilization. A land is also an alienated land if the rent due is paid annually, payment of necessary payment, the category of land use is determined by the state authority, and compliance with the condition and restrictions and interests as imposed. Alienation is only allowing for the state land to be owned by the proprietor. This principle is laid down in the case of Tan Chito and T. Kim Kwek, where the document of title of the appellant is void against the respondent as the lot on dispute could not be alienated by the state authority as it was no longer state land. Upon application, the state authority shall issue the title of alienated land, that is, registry title, as well as land office title, and also the qualified title as provided under Section 77(1)(a) and (b). All these titles give the proprietor the varying rights towards the land. However, the formal title that will mark the alienation of the land of the proprietor as the owner will be the final title. Before attaining final title, after the application of alienation has been approved by the state authority, at the stage where the act of surveying the land made by the surveying officer must be done and accompanied by a certified plan of the land prepared by the director of the survey and mapping as stated in Section 77 Clause 2A and B. Qualified title or hak milik sementara in Section 176 Clause 1 is for the purpose and effect of enabling land to be alienated in advance of survey. The proprietor is yet to attain the exclusive rights of the land, as this is the mere title given at the stage where survey must be done. Following Section 180 Clause 1, where approval of the state authority to alienation of any land has been given, documents of qualified title shall be prepared, registered and issued by the land administrator or registrar. And Clause 2 provides that before the registration of qualified title takes place, all items of land revenue specified shall be paid. After then, once the survey has been conducted and the state authority is satisfied with the land, the payment of revenue of the land will be issued. It is to be made by the applicant before the alienation comes into effect, as stated in Section 81 Clause 1. Following Section 80 Clause 3, upon the approval of alienation of any land by the state authority, and upon payment of all fees and registrars shall prepare, register and issue a qualified title in respect of the land. Consequently, following Section 81 Clause 2, when sums of payment have become due, the intended proprietor is required to pay them within time frame via Form 5A, which has been issued by the land administrator. And, unless paid, the approval of alienation shall thereupon lapse. Consequently, the state land shall be reverted back to the state authority and no documents of title shall be issued to the proprietor. In the case of Teh B and K Maratamutu, the appellant, Teh B, was the registered proprietor of a piece of land in Seremban. The respondent had occupied a hut on the appellant's land. The appellant had made several verbal requests and demands on the respondent to quit the land, but he had failed to do so. Therefore, the appellant issued a notice to quit her land to the respondent, but the respondent failed to comply. Thus, she brought an action. The respondent denied that the appellant is the registered proprietor of the land and maintained that he was the lawful holder of the TOL in respect of the land. Plus, he had been occupying the land since 1952. Respondent then contended that the appellant's title was invalid as it was obtained by fraud, misrepresentation, and by lawful means. The respondent had also paid the license fees for occupation of the land and paid assessment on the building erected by him. Respondent argued that the appellant knew that he was the lawful occupant of the land and he had accepted the alienation of the state land from state authority subject to the incidents attaching to the land. Thus, she was stopped from denying the appellant's right of occupation. It was held at the federal court that the appellant was the only applicant for the alienation of the land. The state authority does not seem to have any intention of alienating the land to anyone else other than the appellant. Thus, it necessarily raised the inference that the state authority had given fresh approval on the amount being paid, although it was outside of the time frame. The court was also of the view that the provision relating to the lapse of approval in section 81 clause 2 is to enable the state authority to give the land to someone else if the approved applicant does not want the land or unable to pay the necessary fees. In conclusion, it is not intended to impose any restriction on the state authority's power to dispose land. Before the payment of the revenue, the title remains with the proprietor of the land would be the qualified title. Once paid by virtue of Form 5, the proprietor has the final title to the alienated land, and Section 92 applies, where their rights will be indefeasible as stated in Tehbi's case. Clause 2 provides the rights of the proprietor whom the state authority has granted the final title of the land. Amongst them would be to subdivide or partition the land or amalgamate with the other land, right to subdivide the building, right to effect transfers, leases, charges, surrenders, and any other permissible dealings, and also right to disposition and devolution of property on death to dispose the land by will. The owner of the land can also enjoy the exclusive rights to the use and enjoyment of land that is within the reasonably necessary above the land and below the surface as stated in section 44(1)(a). Every registered document of title registered shall be conclusive evidence that title to the land described therein is vested in the person or body for the time being, named therein as the proprietor as provided under section 89. Finally, section 78 clause 3 provides that the alienation of state land shall take effect upon the registered document of title thereto pursuant to final title that has been approved by the state authority.
To apply into the situation, the first question arises here is that the land intended to be alienated by Sufyan was previously owned by Malik under TOL. So, did the alienation by Sufyan is valid? To answer that, Malik never paid the annual rent of his land and therefore, according to the case of Tan Chito and T. Kim Kwai, Malik's land has reverted to the state authority and hence making the application of alienation of land by Sufyan is valid. It can be seen that Sufyan is halfway to owning the land as he has gotten the approval from the state authority and being issued with the Form 5A. But he did not yet get the final title of the land as he need to fulfill all the process in alienation such as the requirement in section 180 subsection 1 and subsection 2, Section 81 subsection 1 and Section 80 subsection 3. However, rather than following all the steps first, Sufyan has immediately entered into a sales and purchase agreement to sell the alienated land to his cousin Amir. Sufyan never paid any sums of money as required in Form 5A and therefore it can be safely assumed that Sufyan failed to comply with all the requirements for alienation and hence making the alienation lapse and the land will be reverted back to the state authority. By following the court held in TB and K. Marutamutu, Sufyan is merely an applicant for the alienation of the land when the alienation lapsed, and he never completed the process of alienation. Therefore, Sufyan did not have any legal rights over the land, and it is impossible to transfer the land to Amir. Lastly, as mentioned before, Form 5A has been issued to Sufyan, but it did not constitute to a complete land transfer as in Section 78 subsection 3. Since Sufyan never paid anything to the land office, the alienation lapsed and the land is now known as the state land again. It proved the fact that the land was never being registered under Sufyan's name and thus make Amir has a valid reason to terminate the agreement in order to avoid his interest over the land being legally denied by the virtue of Sufyan's conduct. For the conclusion, Amir has a valid reason to terminate the sales and purchase agreement as the land is a state land and not registered under Sufyan's name.